Hey, it's James, Father's Rights and Resources, hashtag how I got custody. In my store are three items that pretty much every dad needs, unless you're not accused of child abuse or domestic violence, and usually everybody is. So people ask me, what should I get out of your store, or anything in your store, or, they don't know how to navigate the store. If you go to the link in my bio on TikTok, you got to go to my Instagram. There's a link to Instagram, and then you got to go there and then click the link there, and there's my store with the shopping cart in that link. Under YouTube, I'll have a direct link to my store and then a link to my flow page, which leads to my store. But the three things that you're gonna want to seriously consider in my store are the rules of evidence video, the defense against restraining order or abuse claims, and then the motion for a temporary parenting plan, or the arguments for 50-50 or full custody. So I'm going to explain each and every one, but I'll start off with the rules of evidence video because everybody needs to know the rules of evidence. The rules of evidence are basic and fundamental to a court. Just like if you're going to walk on a basketball court, you need to know that you have to dribble the ball wherever you go. If you don't understand that basic fundamental rule, you won't be able to play. You'll get pulled and put on the bench. Or if you don't understand, you walk into a boxing ring, you don't understand punching behind the head or below the belt, or you don't make your weight cut or whatever. You need to know the basic fundamental. You need to know the basic fundamental rules of red light, yield. When you turn, the person on the right is, you got to yield to them or whatever. You need to know some basic fundamental things. And the rules of evidence determine what evidence gets into court. The rules of evidence only allow reliable evidence because the court doesn't want to waste its time on something that's a waste of time in general and stuff that's not reliable, like hearsay is not reliable. So in my rule of evidence video, it's an hour and 20 minutes long. I break down about 10 rules of evidence, the most important ones, and I'll run through them real quick. Most states have this numbering system. It's the same as the federal court civil rules. Some states like California and New York create their own numbering system. Or what they'll do is they'll put a title of a chapter and then they'll still use the rule number. So you have, starting with the ER 402 or evidence rule 402, that's relevance. Evidence rule 403 says even if something is relevant, if the value of it is outweighed by the danger of unfair prejudice, waste of time, needless presentation of cumulative evidence, stuff like that, that can be deemed not admissible, even if it's considered kind of relevant, like, you're violent, but it was so far removed, it was elementary school, or, you got in a fight with somebody at a bar when you used to drink and you're clean and sober now. That could unfairly prejudice you because you're not that same person anymore. So I get into things like that. There's a rule of evidence that judges can't testify. They're incompetent to testify, but judges testify all the time. When a judge declares something and there's no evidence in front of them, they're supposed to react to the evidence. They're not supposed to make up their own testimony, and they do it all the time. Attorneys can't testify. There's ER 602. 605 is the judges can't testify. ER 602 is the personal knowledge rule or foundation. You can't testify unless you have personal knowledge. A witness is called a witness because they actually witnessed something. ER 702. And I actually have a video previewing my rule of evidence video. I'll put that on link also. So I have a YouTube video that gives you a quickie synopsis of the rule of evidence video. And in my store, every packet has a little bit of an explanation what it is. Somebody says, I'm in your store. What does this packet do? The explanation is right there. So then there's expert testimony. Only a psychologist can testify to child psychology, or an expert on forensic whatever can testify to fingerprints or blood or whatever. A drug, chemical dependency professional can testify whether somebody's got a problem, not a lay person, not your brother's cousin's uncle who says that this person has got this problem. So that's evidence rule 702. Then 802 is hearsay. 803 is the exceptions to the hearsay rule, which is what people need to know. Nobody ever knows the exceptions for some reason. And the other thing you should ask yourself, When was the last time I seen my attorney object to something? Objection, irrelevant. Objection, that's inadmissible because of this and that. When was the last time you seen your attorney do that? And I guarantee somebody said something at your last hearing that was inadmissible. Or the other side might object to your stuff, and then your attorney doesn't object to theirs. Whether you have an attorney or not, you need to know the rules of evidence because you need to put your attorney in check and make sure they're doing their job. Or definitely if you're representing yourself, you need to know what's inadmissible or not. And then when they try and shut down a pro se and say, oh, save your objections until it's your turn to talk. I talk about that also. So the rule of evidence rule video. It's the most important thing I've done among all my free videos, among every other packet in my store. That's the most important thing because it's so fundamental and foundational. And if the rules of evidence are not followed, just think about this. If the rules of business or business law is not followed, you have unfair business practices, insider trading, for example. If the rules of basketball are not followed and somebody gets to travel and walk by somebody without dribbling, they have an unfair advantage and they get to move faster. Then they're cheating and they shouldn't have, got the game-winning basket shouldn't have counted. If somebody gets to hit somebody out of bounds or if somebody doesn't cross the goal line and they call it a touchdown on 4th and goal, they've cheated and they won by cheating and it's not fair. Same thing if the rules of evidence are violated. If somebody violated the rules of evidence, that makes for an unfair hearing. When you have an unfair court proceeding, you have no due process. When you have no due process, the judgment is void. But nobody's talking about this. Your attorney's not talking about it, and nobody wants to read the evidence rules. Now, you can Google the stuff, the evidence rules and all the stuff I'm going to talk about. You can Google it and find it on your own. It's just whether you want to spend hours and hours researching it, reading it, finding it, hopefully finding it. Or if you want to just get my packets or my information and just go through it and learn everything you need to know. It's a time saver. You can find everything that I got here. Just like kind of with like any other, like you could do your own tune-up in your own car if you got the time to research how to do it and watch somebody's YouTube video. You could pay a professional to just knock it out who already knows how to do it. The second most important thing is defense against restraining order packet, where I talk about, just about everybody who's gotten this packet has either won or modified their protection order to get the kids off or whatever. And I talk about all the studies, investigations, documentaries, quotes from judges and lawyers and Harvard law professors and investigative articles. I give some articles giving examples of this stuff about how women lie about protection orders to get leverage in custody battles. I even quote a couple different bar associations, California and Illinois. And if you go in there and you say, hey, look, Your Honor, there's entire bar associations who have found that women are using this stuff as gamesmanship. And this lady over here uses domestic violence as a punchline. She's making a mockery of the real women victims of violence who are scared to even come to court, or all the women who fought to get these protection orders in place. She's stomping on their grave or making a mockery of them. I have arguments in there. Now I have Washington law in there that defines domestic violence, things like that. There's some things you got to substitute out of there. It's not like universal for every single person, every single scenario, but all the content about people lying and abusing the system and all the quotes and documentaries and all this other stuff, it's all assembled. Now you can Google false protection orders, false abuse claims, and go get as many quotes as you want. Or you can spend a couple $20 bills and have this stuff ready to go. This would cost you hundreds of dollars for an attorney to argue this and write thousands probably and write it down on paper. And most attorneys aren't even doing this. So just agree to the protection order. You don't want to talk to her, so just agree to it. And now you got domestic violence on your record, and it screws you for your parenting plan. The other one is the motion for temporary parenting plan. And I have a parenting plan packet that has samples of parenting plans with details about, vacations, when somebody passes away, how to interrupt somebody's time to make sure the kids could go to the funeral, all kinds of stuff that nobody thinks of. But I'm not talking about the parenting plan packet. I'm talking about the motion and the argument to get a parenting plan. There's a motion sample in there, and there's a declaration sample. Some courts, like in Washington, you got a motion for temporary orders. The motion's already set. It's a standard form. In California, you got request for order, an RFO form. So I have a motion sample with the arguments, and then I have a declaration in support of the motion. So if you already have a motion form that your state requires you to use, you could write declaration in support of motion. And it talks about all the science and all the data. And you can get that too. That's in my flow page. But it assembles it all together and makes compelling arguments. And it has Washington case law there too, which you can say, hey, look, why don't you look and consider this Washington case law? Your judge doesn't have to consider it. It's not mandatory like case law in your state, but they can consider it. So rule of evidence packet, defense against restraining order packet, and motion for